Chapter 2 Admission to Practice a Judicial Control 1. Admission to practice is a judicial function. The power to admit applicants to the practice of law is judicial in nature and involves the exercise of judicial discretion traditionally exercised by the Supreme Court as an inherent part of its judicial power. Rationale comes from the nature of a judicial function and the role played by attorneys in the administration of justice. The admission to the practice of law requires 1. Previously established rules and principles. By constitutional mandate, a primary responsibility of the Supreme Court. 2. Concrete facts, past or present, affecting determinate individuals, brought about by the applicant for admission to the bar. 3. A decision as to whether the facts are governed by rules and principles, involves judicial adjudication, which is essentially a function of the court. To enable the court to properly discharge its responsibility for the efficient and impartial administration and to elevate and maintain the standard of the legal profession requires that it must have the primary duty to decide A. Who may be admitted to the bar as one of its officers, B. What are the causes for disciplinary action against him, C. Whether he should be disciplined, suspended, disbarred, or reinstated. Any legislative or executive judgment substituting that of the Supreme Court in the admission to the practice of law or suspension, debarment, reinstatement infringes upon and constitutes as an invalid exercise of the legislative or executive power. 2. Legislative power to repeal, alter, or supplement the 1935 and 1973 constitutions provide that the Supreme Court shall have the power to promulgate rules concerning the admission to the practice of law, but may be repealed, altered, or supplemented by the Batasang Pambansa. The 1987 Constitution deleted such provision. The legislature may, however, enact laws with respect to the first requisite for the admission to the bar, previously established rules and principles that applicants should observe. A. The legislature may pass a law for additional qualifications for candidates for admission to the practice or filling up deficiencies in the requirements for admission to the bar. B. Such law may not, however, be given retroactive effect so as to entitle a person, not otherwise qualified, to be admitted. C. Such law will not preclude the Supreme Court from fixing other qualifications and requirements. Reason: legislature has no power to grant a layman the privilege to practice law nor control the Supreme Court in its responsibility to decide who may be admitted. The legislature, in the exercise of its police power, may, however, enact laws regulating the practice of law to protect the public and promote the public welfare. 1. A law declaring illegal and punishable the unauthorized practice of law. 2. Require further examination for any attorney desiring to practice before any quasi-judicial or administrative agency. Whatever law may be passes is merely an aid of the judicial power to regulate, but the legislature may not pass a law that will control the Supreme Court in the performance of its function to decide who may enjoy the privilege of practicing law, and any law of that kind is unconstitutional as an invalid exercise of legislative power. A. 972. The Bar Flunkers Act aims to admit to the bar those candidates who suffered from insufficiency of reading materials and inadequate preparation. By its declared objective, the law is contrary to public interest because it qualifies 1,094 law graduates who confessedly had inadequate preparation for the practice of the profession. As was exactly found by this tribunal in the aforesaid examinations, an adequate legal preparation is one of the vital requisites for the practice of law that should be developed constantly and maintained firmly. 3. Executive power in relation to practice. The chief executive cannot, by executive order, admit a person to the practice of law, nor can he, by treaty with another country, modify the rules on the admission to the bar. A treaty cannot be so interpreted as to entitle a holder of a law degree obtained in another country to practice law in this country without complying with the requirements of existing law accordingly. A Filipino citizen who obtained a law degree in another country is not entitled to be admitted to the Philippine bar without complying with the requirements for prescribing standards for law schools. CHED acts as an agency or an aid of the Supreme Court in the exercise of its primary authority to determine who may be admitted to practice, and such authority is by constitutional mandate and rests and remains exclusively with the High Tribunal. CHED merely 1. Exercises regulatory power over law schools or certifies as to the satisfactory completion of the prescribed courses of law study by an applicant for admission to the bar examination. 2. Assumes some responsibility for the quality of instruction and training required of an applicant for membership in the bar. 4. Supreme Court incidental powers. Incidental to its primary authority to decide who may be admitted to the bar. 1. Fixing minimum standards of instruction for all law schools to observe. 2. Setting up of the necessary administrative machinery to determine compliance therewith. 3. By way of sanction, refusal to admit to the bar exams law graduates from schools failing to meet those standards may be implemented through accreditation. B. What constitutes practice of law? 1. Practice of law. Generally, general principles and doctrines laid down by the courts explaining the meaning and scope of the term. 1. To engage in the practice of law is to do any of those acts which are characteristic of the legal profession. 2. Any activity in or out of court which requires the application of law, legal principle, practice or procedure and calls for legal knowledge, training and experience. 3. It is not limited to the conduct of cases in court. 4. Includes legal advice, counseling, and the preparation of legal instruments and contracts by which legal rights are secured, which may or may not be pending in court. 5. Strictly speaking, the word practice of law implies the customary or habitual holding out of oneself to the public as a lawyer and demanding compensation for his services. 2. 3 principal types of professional activities. 1. Legal advice and instructions to the clients to inform them of their rights and obligations. 2. Preparation for clients of documents requiring knowledge of legal principles not possessed by ordinary laymen. 3. Appearance for clients before public tribunals. Notes: when a person participates in a trial and advertises himself as a lawyer, he is in the practice of law giving advice for compensation regarding the legal status and rights of another constitutes practice of law. One who renders an opinion as to the proper interpretation of a statute and receives pay for it is to that extent practicing law. Engaging in the practice of law presupposes the existence of a lawyer-client relationship where a lawyer undertakes an activity without any such relationship, such as teaching law or writing law books or legal articles, cannot be said to be engaged in the practice of his profession as a lawyer. 3. Characteristics of term practice of law. The phrase practice of law implies customarily or habitually holding oneself out to the public, as a lawyer, for compensation as a source of livelihood or in consideration of his service. Holding oneself out may be shown by acts indicative of that purpose. Thus, a layman is illegally engaged in the practice when he sends a circular announcing the establishment of a law office for the general practice of law, or when he takes the oath of office as a lawyer before a notary public and files a manifestation with the Supreme Court informing his intention to practice law. Private practice consists of frequent and customary actions. More than an isolated appearance, it contemplates succession of acts of the same nature habitually and customarily holding oneself out to the public as a lawyer. 4. Isolated appearance. A judge who is prohibited from engaging in private practice of law has not violated this prohibition when he appeared as counsel for his cousin pro bono in a criminal case. The appearance as counsel in one occasion is not conclusive as determinative of engagement in the practice of law. See appearance of a city attorney as private prosecutor not within the prohibition. Notes: an isolated appearance may, however, amount to practice. 1. Legislator cannot appear as counsel before any court of justice or electoral tribunals, or quasi-judicial and administrative bodies even in a single instance. 2. A layman's representation as defense counsel in a criminal case is invalid and the conviction of the accused may be set aside, as violative of due process. 5. Representation before the court, practice of law, as customarily understood, means 1. Rendering of services to a person, natural or juridical, in court on any matter through various stages and in accordance with rules of procedure. 2. Appearance before the court. 3. Preparation and filing of a pleading, motion, memorandum, or brief. 4. Examination of witnesses and presentation of evidence. 5. Management and control of the proceedings in court. 6. Representation before other agencies. Appearances before any quasi-judicial, administrative, or legislative agency constituting practice of law. 1. Interpretation and application of laws. 2. Presentation of evidence to establish certain facts. 3. Representing an applicant for registration of trademark, trade name, or service mark in the Philippine Patent Office. 4. Advocating or resisting claims before the NLRC, BOC, or BIR. 5. Representing before a legislative body regarding a proposed legislation or ordinance. Character of the service and not the place where it is performed is the decisive factor determinative of whether the service constitutes practice of law. Service to prepare and prosecute a just claim before a quasi-judicial or administrative body same and legitimate as the service rendered in court in arguing a cause. 7. Activity outside of court. Practice of law also consists of work performed outside of court, giving legal advice on large variety of subjects, conveyancing and preparation and execution of legal instruments covering an extensive field of business and trust and other affairs. No valid distinction can be drawn between part of the work involving appearance in court and that part involving advice and drafting of instruments in his office. Practice of law need not be habitual services in litigations in court. A person's past work experiences as lawyer economist, lawyer manager, lawyer entrepreneur of industry, lawyer negotiator of contracts, and lawyer legislator more than satisfy the constitutional requirement for appointment as chairman of the Comelec that he has been engaged in the active practice of law for at least 10 years. 8. Essential criteria determinative of engaging in the practice of law. 1. Habituality implies customarily or habitually holding oneself out to the public as a lawyer. 2. Compensation implies that one must have presented himself to be in the active practice and that his professional services are available to the public for compensation, as a source of his livelihood or in consideration of his said services. 3. Application of law, legal principle, practice, or procedure which calls for legal knowledge, training and experience. 4. Attorney-client relationship. CWHO may practice law. 1. Persons entitled to practice law. Generally any person who has been duly licensed as a member of the bar in accordance with the statutory requirements and who is in good and regular standing is entitled to practice law. 2. Basic statutory requirements. 1. Must have been admitted to the bar. 2. After admission, must remain in good and regular standing, a continuing requirement. Notes: must have been admitted to the bar. A lawyer is one who 1. Passed the bar exams, 2. Taken the lawyer's oath before the Supreme Court en banc. 3. Signed in the role of attorneys. 4. Received a certificate of license to practice law from the clerk of court of the Supreme Court. 5. Furnished satisfactory proof for educational, moral, and other qualifications. After admission, he or she must 1. Remain an IBP member in good standing by regularly paying IBP dues and other lawful assessments. 2. Pay annual privilege tax. 3. Faithfully observe the rules and ethics of the legal profession. 4. Be continually subjected to judicial disciplinary control. Compulsory membership to the IBP is not violative of a lawyer's freedom of association. Integration does not make a lawyer a member of any group of which he is already a member. He became a member of the bar when he passed the bar examinations. Bar integration does not compel the lawyer to associate with anyone. He is free to attend or not attend the meetings of his integrated bar chapter or vote or refuse to vote in its elections as he chooses. The only compulsion to which he is subjected is the payment of annual dues. The Supreme Court, in order to further the state's legitimate interest in elevating the quality of professional legal services, may require that the cost of improving the profession in this fashion be shared by the subjects and beneficiaries of the regulatory program. The lawyers, the rigid requirements and conditions are designed to admit to its ranks only those who are adequately prepared, mentally and morally, to discharge the duties of an attorney. The purpose, in the final analysis, is to protect the public, the court, the client, and the bar from incompetence and dishonesty of those who are unfit to become members. Only those who are competent, honorable, and reliable may practice law. 2. Right and privilege to practice. The practice of law is not a natural property or constitutional right but a mere privilege. It is not a right granted to anyone who demands it but a privilege to be extended or withheld in the exercise of sound judicial discretion. It is in the nature of a franchise conferred only for merit which must be earned by hard study, learning, and good conduct. It is a privilege accorded only to those who measure up to certain rigid standards of mental and moral fitness. Those standards are neither dispensed with nor lowered after admission. The attorney's continued enjoyment of the privilege conferred depends upon his complying with the ethics and rules of the profession, but practice of law is in the nature of a right. While the practice of law is a privilege, a lawyer cannot be prevented from practicing law except for valid reasons. The practice of law not being a matter of state's grace or favor, he holds office during good behavior and can only be deprived of it for misconduct. The state cannot exclude an attorney from the practice of law in a manner or for reasons that contravene the due process or equal protection clause of the Constitution. A quasi-judicial or administrative agency cannot restrict a lawyer's privilege to practice law by imposing conditions that amount to discrimination, nor limit such privilege by requiring the passing of an examination not sanctioned by law as a prerequisite to appearing before such agency. In that sense, the practice of law is in the nature of a right which cannot be lightly or capriciously taken away from him. 3. Practice without examination. Exceptions to the privilege afforded to Filipino citizens who have passed the bar exams to practice law. Citizens of the United States who 1. Before July 4, 1946, were duly licensed members of the Philippine Bar. 2. In active practice in the courts of the Philippines. 3. In good and regular standing as such. 4. Took the oath of office pursuant to the Comity Clause of the then Rules of Examination of Candidates for Admission to the Practice of Law in the U.S. during the American regime. B. Filipino citizens, in the discretion of the court, may be admitted without examination, who 1. Are applicants for admission and are enrolled attorneys in good standing in the Supreme Court of the United States or in any circuit court of appeals or district court therein, or in the highest court of any state or territory of the United States. 2. can show certificates that they have practiced before July 4, 1946. 3. Have never been suspended or disbarred. Rule 138. Sec 4. Rules of Court. Practice without admission. Notes. General Rule. Only those who are licensed to practice law can appear and handle cases in court. Exceptions. 1. Before the MTC, a party may conduct his case or litigation in person with the aid of an agent or friend appointed by him. Sec 34. Rule 138. 2. Before any other court, a party may conduct his litigation personally. Sec 34. Rule 138. He is bound by the same rules in conducting the trial of his case. He cannot, after judgment, claim that he was not properly represented. 3. In a criminal case before the MTC in a locality where a duly licensed member of the bar is not available, the judge may appoint a non-lawyer who is a resident of that province, of good repute for probity and ability to represent the accused in his defense. Sec 7. Rule 116. 4. Student Practice Rule. A law student who has successfully completed his third year of the regular 4-year prescribed law curriculum and is enrolled in a recognized law school's clinical legal education program approved by the SE may appear without compensation in any civil, criminal or administrative case before any trial court, tribunal, board or officer, to represent indigent clients accepted by the legal clinic of the school. Sec 1. Rule 138A. The student shall be under the direct supervision and control of a member of the IBP duly accredited by the law school. Sec 2. 5. Under the Labor Code, non-lawyers may appear before the NLRC or any labor arbiter if they a. Represent themselves, b. Represent their organization or members thereof. Art 222, PD 442. 6. A non-lawyer or layman may represent a claimant before the cadastral court. Sec 9. Act No. 2259. 7. Any official or other person appointed to appear for the government of the Philippines in accordance with law shall have all the rights of a duly authorized member of the bar in any case in which said government has an interest. Sec 33. Rule 138. Notes. 3 limitations in the appearance of a layman on behalf of another. 1. Layman should confine his work to non-adversary contentions. Should not undertake purely legal work such as examination of witnesses or presentation of evidence. 2. Services should not be habitually rendered. 3. Should not charge or collect attorney's fees. 4. Right of party to represent himself in civil cases. Individual litigant has the right to conduct his litigation personally. He will still be bound by the same rules of procedure and evidence as those applicable to a party appearing through counsel. He may not be heard to complain later that he has been deprived of the right to the assistance of counsel in criminal cases involving grave and less grave offenses. An accused who is a layman must always appear by counsel. He cannot conduct his own defense, as his right to counsel may not be waived without violating his right to due process of law by a juridical person. General Rule. It must always appear in court by a duly licensed member of the bar. Exception. In the MTC, it may be represented by its agent or officer who need not be a lawyer. 5. Practice by corporation. It is well settled that a corporation cannot engage in the practice of law. It may, however, hire an attorney to attend to and conduct its own legal business or affairs, but it cannot practice law directly or indirectly by employing a lawyer to practice for it or to appear for others for its benefit. Reasons. 1. Nature of the privilege and on the confidential and trust relation between attorney and client. 2. The corporation, a juridical person, cannot perform the conditions required for membership in the bar, such as the possession of good moral character and other special disqualifications, The taking of an oath and becoming an officer of the court, subject to its discipline, suspension or removal. 3. The relation of trust and confidence cannot arise where the attorney is employed by a corporation to practice for it, his employer and he owing, at best, a secondary and divided loyalty to the clientele of his corporate employer. 4. The intervention of the corporation is destructive of the confidential and trust relation and is obnoxious to the law. 6. Persons authorized to represent the government, any official or other person appointed or designated in accordance with law to appear for the government of the Philippines or any of its officials shall have all the rights of a duly authorized member of the bar to appear in any case in which the government has an interest, direct or indirect, or in which such official is charged in his official capacity. Sec. 33. Rule 138. Solicitor General, Assistant Solicitor General, solicitors and trial attorneys, state prosecutors, special counsel, special prosecutor of the Ombudsman. 7. 3 instances when a lawyer cannot practice. 1. Appearance of parties in person. In all Katarungang Pambarangay proceedings, the parties must appear in person without the assistance of counsel or representative, except for minors and incompetents who may be assisted by their next of kin who are not lawyers. SEC 415. Local Government Code. 2. Appearance through a representative must be for a valid cause. The representative of an individual party must not be a lawyer, and must be related to or next of skin of the individual party. Juridical entities shall not be represented by a lawyer in any capacity. AM number 0887 SC. Rule of procedure for small claims cases.